Hello everyone, welcome to Courts Today by LiveLaw, your go-to source for the latest and fastest legal updates. I'm your host Urvashi Chauhan, bringing you daily developments, landmark judgments and significant rulings from the world of law. Let us begin with the headlines and a concise overview of the top stories. After that, we will delve into the full details. Supreme Court has held that plea of juvenility can be raised even after conviction and sentence attained finality. The Delhi High Court has issued notice on a plea to allow Sonam Wangchuk and others from Ladakh to hold peaceful protest at Jantar Mantar. The Delhi High Court has issued notice on a PIL against ticket scalping over recent music concerts. The Bombay High Court has held that Shirdi Sai Sansthan is a religious and charitable trust and thus its anonymous donations cannot be taxed. Bollywood actor Shilpa Shetty and her husband Kundra have moved the Bombay High Court against notice for eviction from residence and farmhouse. And due to missing trial court records, the Allahabad High Court has acquitted a man in the 1982 murder case. The Supreme Court has observed that plea of juvenility can be filed even after the judgment and order of conviction and sentence has been granted against a person and it has attained finality. In this particular case, the accused had filed an application claiming the plea of juvenility even after the Supreme Court had upheld his conviction. After this, on direction of the top court, a detailed examination was done by the Sessions Court under Section 94 of the Juvenile Justice Care and Protection Act of 2015, determining the age of the accused at the time of commission of the offence. It was concluded that the accused was below 18 years of age as on the date of the incident. Accepting the Sessions Court's report, the bench comprising Justices B.V. Nagratna and N. Koteshwar Singh accepted the claim of juvenility, set aside the conviction and acquitted the accused in the murder case. The Delhi High Court has today sought response of the Delhi police on a petition seeking permission to allow climate activist Sonam Wangchuk and his associates from Ladakh to hold peaceful protest at Jantar Mantar. They wish to raise environmental awareness and demand 6th schedule status for Ladakh. A division bench comprising of Justice Pratibha M. Singh and Justice Amit Sharma also sought response of the Delhi government. The plea was filed by apex body LiveLaw, an organization working towards protecting Ladakh's cultural environmental interests. The organization initiated the march with approximately 200 Padyatris, including Wangchuk, and began the Padyatra from Leh to New Delhi. Solicitor General Tushar Mehta told the court today that there was no urgency for holding the dharna and therefore time may be granted to the authorities for filing replies to the petition. While issuing notice to the Delhi police and the Delhi government, the court ordered for the replies to be filed by 16th October and listed the matter for hearing on 22nd October. Recently, many people in India faced problems with ticket scalping, especially for music concerts by Coldplay and singers Diljit Dosanjh and Karan Aujla. Fans who were excited to attend these concerts were disappointed when tickets sold out quickly, only to be resold by scalpers at much higher prices. Scalpers used bots to buy tickets in bulk and then sold them for far more than the original price, making it difficult for real fans to afford them. In this regard, the Delhi High Court today issued notice on a PIL against the practice of ticket scalping, a process where tickets to an event are bought with the intention of reselling them at a higher price. The PIL has been filed by one Rohan Gupta, who is engaged in providing photography and videography services, seeking formation of guidelines to prevent the menace of black marketing of tickets. In the alternative, he seeks that the ticket scalping practice must be taken within the purview of law. The petition further seeks formation of a committee to look into this practice and framing of clear guidelines to prevent predatory resellers from illegally and without any authorization engaging in activity of black marketing of tickets. During the hearing today, Delhi Government's counsel Santosh Kumar Tripathi submitted that the issue is covered under Section 112 of the Bharatiya Nyaya Sanhita 2023, which deals with petty organized crime. It defines petty organized crime as any illegal act committed by a member of a group or a gang, either alone or jointly. These acts include theft, cheating, snatching, unauthorized sale of tickets, selling public examination question papers, etc. He submitted that if the practice of illegal sale of tickets is a criminal offence covered under BNS, then guidelines cannot be issued over and above what is described as an offence. However, a bench of Chief Justice Manmohan and Justice Tushar Rao Gadela proceeded to issue notice and sought response of the Union government and the Delhi government. In the next update, the Bombay High Court has held that Shirdi Sai Baba Sansthan Trust Shirdi is certainly a religious and a charitable trust. And thus, the anonymous donations of around 159 crores that it received in the cash collection box between 2015 and 2019 can be exempted from income tax. The IT department had contended that the trust, being a charitable one, and as the anonymous donations exceeded 5% of the total donations, the same were taxable. The department also argued that out of the total amounts received under donations, a minuscule amount was used for religious purposes, which is contrary to the claim of the trust that it also has religious obligations. On the other hand, the trust contended that it has both religious and charitable obligations, and thus its anonymous donations cannot be taxed. A division bench of Justices Girish Kulkarni and Som Shekhar Sudarshan upheld the 2023 order of an income tax appellate tribunal, which had held that the trust is both a charitable and a religious one, and thus was eligible for exemption from income tax on its anonymous donations. The bench thus dismissed the appeal filed by the IT department. To read in detail about the observations made by the court, please visit LiveLaw.in. In another update, Bollywood actor Shilpa Shetty and her businessman husband Raj Kundra both have moved the Bombay High Court challenging the eviction notices issued to them. This was after their residential premises in Mumbai's Juhu area and farmhouse near Pauna Lake were provisionally attached by the Enforcement Directorate in connection to an alleged crypto assets Ponzi scheme case. The couple has been facing action since 2018 when the ED lodged a case against one Amit Bhardwaj in the scheme, wherein the Kundra couple allegedly with other co-accused duped investors of over 6 crores in the form of bitcoins. In their petition, the couple has sought orders to protect their right and shelter of their family against the meaningless, reckless and arbitrary act on the part of Enforcement Directorate for issuing eviction notices on 27 September, directing the couple to vacate their properties within 10 days. The petition seeks to quash and set aside the eviction notices, saying that they have been cooperating with ED and has attended to all the summons sent to them between 2018 and 2024. A division bench of Justices Revati Moite Dere and Prithviraj Chavan has issued notice, and the matter will be heard tomorrow. And lastly, the Allahabad High Court has acquitted the sole surviving accused in a 42-year-old case after it received a report from the District Judge Belia that the entire record of the case had been weeded out and the reconstruction of same was impossible. A bench of Justice Nalin Kumar Srivastava passed this order while hearing an appeal filed by Sri Ram Singh against the conviction judgment and 4-year imprisonment passed by a sessions court in September 1982. The trial court had convicted him in connection with a case of murder and destruction of evidence. In his appeal, the prosecution admitted that reconstruction of the record is not possible, and no other record except the impugned judgment and order of the trial court is available. The district court also sent a report in this regard. Taking into account the circumstances of the case, the court referred to various judgments of the High Court as well as of the top court to note that if substantial portion of trial court record is not available before the appellate court, an endeavour should be made firstly for reconstruction of the record, and if only reconstruction is not possible to facilitate the High Court to hear and dispose of the appeal, then possibility should be looked into for retrial of the case. And if due to loss of vital and basic records of the trial court, retrial and fresh adjudication of the matter is also not possible, then in that case, the impugned judgment and order should not be permitted to operate and the matter shall stand closed. Thus, finding no other alternative in these circumstances, the court allowed the appeal and set aside the conviction and sentence and acquitted the appellant. For more details on the cases mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on LiveLaw. Please do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.